Hello everyone and welcome to Affairs Cloud. In today's video, we are going to take a look at the second amendment to the Companies Act of 2013. So what is the Companies Act of 2013? What was the first amendment and what was the second amendment that was passed on March of 2020 are all things that we will look into detail in the video. So let's proceed to the video. To amend the Companies Act of 2013 was approved by the Union Government on 4th of March 2020. It is to be noted here that the Act was previously amended on July 30th, 2019. In the current amendment, there are a total of 72 changes in the 65 sections of the Act. The focus of these changes are primarily regarding decriminalization of various provisions of the Act, that is, in a sense, to lessen the criminal penalties in relation to certain sections of the Act, and also to permit direct overseas listing of Indian corporates, which will enable them to raise capital from around the world. The Union Government had appointed a high-level panel, and the panel had proposed in November to decriminalize more than half of the existing compoundable offences under the Act, and had also proposed to lower the monetary penalties for violations by startups. The intention of the proposals was to further improve the ease of doing business in the country. In accordance with the recommendations of the panel, the Union Government cited that improving the conditions and regulations to improve the ease of doing business as the main motive behind the amendment. Now let's take a look at the first amendment to the Companies Act that was passed on July 30th, 2019. So taking a look at the changes that was made by the amendment, the first is with regards to issuance of dematerialized shares. So dematerialization is a process through which an investor's physical share certificate gets converted to electronic format. Now dematerialization is usually referred to as DMAT, and the intention of dematerialization is to avoid risks associated with paper format share transactions. So under the Act, certain classes of public companies are now required to issue shares only in dematerialized forms. The bill also states that this may be prescribed for other classes of unlisted companies as well. The second change is with regards to beneficial ownership. So what's beneficial ownership? It's a legal term that refers to anyone who enjoys the benefit of ownership of a property without being on record as the actual legal owner. So in accordance with the Act, if a person holds beneficial interest of at least 25% shares in a company or exercises significant control over the company, that person will now be required to make a declaration of his or her interest. The bill also requires that every company takes steps to identify an individual who may be a significant beneficial owner and also requires their compliance under the Act. The first amendment to the Companies Act had recategorized certain offences under the Act. Under the original Companies Act of 2013, there were 81 compoundable offences that are punishable with fine or imprisonment or both, depending on the crime. So a compoundable offense is an offense where the complainant, that is the one who has filed the case, enters into a compromise and agrees to have charges dropped against the accused. So that is a compoundable offense. Now compoundable offenses are heard by courts, but the amendment bill had recategorized 16 of the compoundable offences as civil defaults. Now, since it was recategorized as a civil default, it will now be heard by adjudicating officers that are appointed by the central government, and they will now levy financial penalties in place of imprisonment. So the provision for imprisonment has been removed in these 16 offences. So example of these offences include issuance of shares at a discount, failure to file annual return, etc. Further, the bill has also amended the penalties for few other offences. Now let's take a look at the changes in corporate social responsibility regulations that was brought about by the first amendment to the Companies Act. So CSR or corporate social responsibility is in essence a type of private business self-regulation that aims to contribute positively on the society. Now this contribution could be achieved through monetary help such as charity, or it could be achieved in any other way that aims to leave a positive impact on the society on fields such as education, eradication of poverty, eradication of hunger, abolition of gender inequality, etc. So, under the original act, companies that have to provide for CSR that do not fully spend the funds had to disclose the reasons for non-spending in their annual report. Now, under the amendment bill, any unspent annual CSR fund must be transferred to one of the funds under Schedule 7 of the Act. For example, it could be transferred to Prime Minister Relief Fund, and this should also be transferred within 6 months of the financial year. However, if the CSR funds are committed to certain ongoing projects of the firm, then the unspent funds will have to be transferred to an unspent CSR account within 30 days of the end of the financial year and spent within 3 years. Any funds remaining unspent after 3 years will have to be transferred to one of the funds under Schedule 7 of the Act. So, just like we had mentioned, if it was not spent for 3 years, then it will have to be transferred to one of the funds, like for example Prime Minister Relief Fund under Schedule 7 of the Act. So these are the changes brought in the CSR regulations. Now regarding compounding, that is settlement of offences without proceeding to prosecution, under the original act, a regional director could compound, that is settle offences with a penalty of up to 5 lakh rupees. Now the amendment bill has increased this settlement ceiling to 25 lakh rupees. Now regarding change on bar on holding office, under the original act, the central government or certain shareholders can apply to the NCLT, that is the National Company Law Tribunal, for relief against mismanagement of the affairs of the company. The amendment bill states that in case of such a complaint, the government may now also make a case against an officer of the company on the ground that he is not fit to hold office in the company for reasons such as fraud or negligence. Now, if the National Company Law Tribunal NCLT passes an order against the officer, the amendment bill makes it such that he or she will not be eligible to hold office in any company for 5 more years in the future. So this is the change that has been brought about by the amendment with regards to the bar on holding office. So now let's take a look at the second amendment to the Companies Act that was passed on 4th of March 2020. So the primary focus of the second amendment was with regards to decriminalization and improved ease of doing business. So with regards to decriminalization, 66 compoundable offences under the Act are now to be changed. Out of these 66 offences, 23 will be recategorized under the amendment. 7 offences will now be omitted altogether. 11 offences will be changed or altered to a civil default and hence will have limited punishment in the form of monetary fines, and the imprisonment provision will now be removed in those 11 offences. 5 offences will be dealt with alternative different frameworks. 6 offences which had earlier been decriminalized will now be criminalized but will have reduced quantum of penalties. Also, overall monetary penalties have been lowered for violations by startups. Now there are 52 proposals that would result in 48 amendments for greater ease of doing business for corporates, and this is by way of removing criminality totally in respect of 35 procedural and technical defaults that was previously considered to be illegal. Few other changes have been brought to the Companies Act by the Second Amendment. Now let's take a look at those other changes. Now the amendment that has been carried in section 23 of the Act now allows direct listing of securities by Indian public companies in permissible foreign jurisdictions, and this enables these companies to raise capital easily. Also, relaxation in corporate social responsibility (CSR) compliance requirements, as companies that have an obligation to spend rupees 50 lakhs per annum or lesser than or equal to 50 lakhs per annum on CSR are no longer required to have a CSR committee. So if your spendings are less than or equal to 50 lakhs per annum on CSR, you no longer require a CSR committee. Also, companies which spend over the obligated 2% on CSR in a particular year can, after this amendment, carry it forward as credit for fulfillment of CSR obligations for the next few years. Also, another proposal that has been made by the amendment is the creation of separate benches at the National Company Law Appellate Tribunal (NCLAT). So this concludes our changes that have been brought by the Second Amendment Bill to the Companies Act. Thank you for watching. I hope you liked our video. Please leave your feedback in the form of comments, and please remember to subscribe to our channel. Thank you.